We're here with Sophie Feal of the Volunteer Lawyers Project. She's a supervising immigration attorney. So, Sophie, can you describe to me what the Volunteer Lawyers Project does and what your role is here?
VLP is a project of the Erie County Bar Association created to provide pro bono legal services to low-income and indigent members of our community. We provide civil legal services. We do not do any criminal work. We also are engaged in the recruitment, training, and mentoring of private attorneys to give that pro bono work, to do the pro bono work for our clients.
Mm-hmm.
And my role is I am the supervisor of the immigration unit here. We have a staff of 4 lawyers, myself and 3 staff attorneys, and we provide immigration representation, mostly in the areas of immigrants, non-citizens who are detained by immigration,
Mm-hmm.
Immigrants who are subject to violent crimes, human trafficking, and domestic violence. And then we have a grant to help unaccompanied minors who are immigrants who are in the United States.
Mm-hmm. Okay. So one of the main focuses of our discussion is detention and how one gets to be detained. So for starters, for asylees that are seeking status in the U.S., can you describe the difference between affirmative and defensive proceedings?
An affirmative case is a person who enters the United States by some means, whether it's with a visa or whether it's illegally by crossing the border. They are here. They have not been apprehended by immigration authorities, and they ask for asylum. The asylum process affirmatively is to prepare an application, and then you are interviewed by an officer of Citizenship and Immigration Services Asylum Unit. There are 7 asylum units throughout the country. Buffalo is in the jurisdiction of the Newark, New Jersey Asylum Unit. And they come up here on a rotating basis and interview people to determine whether they should be granted asylum or referred to an immigration court, which is the equivalent of being denied. Someone who is presenting an application for asylum defensively is someone who has been apprehended by the immigration authorities, either because they are out of status, they came with a visa but they overstayed their status or otherwise violated their status, or they're illegally present in the United States, or they're deportable for some other reason. So they've been apprehended and placed in deportation proceedings, and this is their defense against removal.
Mm-hmm. So asylees obviously don't have a choice between these two processes. This is
If you're not
fine.
caught, you have a
Right.
choice.
Right.
You're going to go affirmative,
Right.
obviously. But if you're in detention, if you're in removal proceedings,
Mm-hmm.
yeah, you
Right.
have to.
Right.
You get one bite at the apple, not 2, if you will.
Right. Okay. For the defensive proceedings or for both proceedings, are asylees provided a right to an attorney?
No, there is no right to counsel at government expense in deportation proceedings as a whole.
Mm-hmm.
They are seen as civil proceedings, not criminal proceedings.
Mm-hmm.
So the right to counsel doesn't apply. The constitutional right to counsel does not apply because it's a civil case. In any civil case, you have a right to have an attorney represent you, but not at government expense.
Mm-hmm.
So the same applies to immigration proceedings. Now, in 2003, the Department of Justice created a program to furnish legal orientations to people that were detained by the immigration authorities, and that means going into the detention facilities and telling people about their rights. We were among 7 organizations in the country at the time that were funded to do this work, specifically because the detention facility in Batavia, the Buffalo Federal Detention Facility in Batavia, had just begun operations in 1998.
Mm-hmm.
That program has now expanded. I believe there are 24 nonprofit organizations, including VLP, that provide this service in just under 30 detention facilities nationwide.
Mm-hmm.
So that is allowed. We go in and we give information, orientations, both in a group setting and individualized. And we can recruit pro bono lawyers to represent these folks
Mm-hmm.
Before the courts, but we can't use that funding source to directly represent them.
Mm-hmm.
It's my understanding that in the new immigration bill that has just been released by the Senate, there may be a right to counsel at government expense for juveniles, for unaccompanied minors, and possibly for the mentally ill in the future. Of course, that's just a bill. We have no idea what what will be in it when it goes to vote.
So essentially our most in defense proceedings are just receiving counsel. They're not actually represented necessarily.
They're receiving counsel if they're fortunate enough to be in one of the detention facilities where there's a program.
Right.
But if there's no program, they're not even receiving anything unless they can afford counsel, or there's some sort of legal aid program or its equivalent in that jurisdiction that they can call on to represent them for free. We know that 84% of people in detention, non-citizens in detention, don't have counsel.
Mm-hmm.
That is well known.
Meaning that they don't have any education on what they're like.
Well, meaning that they don't have counsel. Their level of knowledge is, we don't know that, but
right.
They don't have attorneys.
Right, exactly. Okay. So I guess I was curious on your opinion, if you're willing to say, of how fair that system is in terms of providing that knowledge or that counsel. Yes.
Because knowledge and counsel are different. Because
Right,
knowledge
right.
is just giving them information, whereas counsel is actually speaking on their behalves as attorneys and defending them in deportation proceedings. Well, it's definitely a problem. I mean, I'm not the first to say it, as federal courts have said it, that the consequences of deportation are very severe. Some people consider them more severe than, for example, the consequences of committing a crime when you consider, imprisonment. Here, it's banishment from perhaps the country that you've been raised in the cases of long-term permanent residents who came here as children and are now being subject to removal because they've been convicted of a crime, for example. Sending them back to these countries means that they may have no family left in those countries. They might not speak the language of the country anymore. They are leaving behind wives, children, and other relatives. So the implications are very serious. And to that extent, it's unfortunate that the government does not provide them with counsel at government expense, has no kind of public defender system for removal proceedings.
So when you're put in immigration court, so when you're in defense proceedings, I'm curious to understand, so just so we have an overview, can you understand who oversees the court cases? Who's overseeing like the individual cases themselves?
I can tell you who the players are.
Right.
Okay, so you have immigration judges.
Mm-hmm.
Immigration judges are employees of the Executive Office for Immigration Review of the United States Department of Justice.
Mm-hmm.
That organization, EOIR, oversees the immigration courts in the United States. I believe there's around 52 of them. And the Board of Immigration Appeals, which is the administrative appellate body that hears the appeals from the immigration courts. The government's attorneys are with the offices of Chief Counsel of the Department of Homeland Security. Okay. The detention facilities are run by Department of Homeland Security Immigration and Customs Enforcement. And then you have the respondent, the person in removal proceedings who may or may not have counsel.
Okay. In your opinion, again, do you think that the system for decision making is transparent?
Transparent. I would think transparent, if you're going to use that word. I mean, the proceedings are recorded. You can access the transcript of the proceedings. An immigration judge makes a decision. If there's an appeal, you get a copy of that decision transcribed. Sometimes immigration judges make decisions written. So transparency, yes, by and large. It's a hard word to decipher. In terms of whether they're fair, there have been criticisms made that the immigration judges are terribly overworked. Terribly overworked. The amount of cases in the system is overwhelming. Immigration judges don't have individual clerks like federal court judges or even state court judges to help them through their caseload. So the system is buried with very little resources. In fact, if you compare the resources that EOIR has compared to the resources that the Department of Homeland Security has, just plain old money, there's a huge imbalance. And I know this because our funding source is EOIR. I mean, we have our contract through them to do the Know Your Rights work. So I have seen comparisons of the two budgets.
And obviously, does this have an implication for asylees who are applying?
Oh, it probably has an implication. Yeah, yeah. I mean, when you have judges that have are overwhelmed with cases and have basically 3 hours set aside in the morning or an afternoon to hear an asylum case, which can be very complex, which can involve lots of factors, which can address situations that we're not the least bit familiar with, it can be a daunting experience for everyone involved.
Are there attempts being made to reform that system right now?
No, I don't think there's an attempt to reform it other than to try to allocate more money towards it so there's more resources. But in terms of overhauling the way these cases are handled, there's no change, and there's no proposed change in this bill that I'm aware of.
Okay. And so moving on towards detention right now. So for those, first of all, why don't we just explain the process of detention and the purpose of it? So why is an immigrant detained in the first place?
Well, detention is authorized generally when a person is not lawfully in the United States and is subject to deportation or has some sort of violation of the U.S. immigration laws. So who are the people who are mostly held in detention? That would be people who overstay their visas. They might have come in legally as tourists or students, but they violate or overstay their visas. They would be people who came into the United States illegally, crossed a border illegally, and are found to be present in the United States without authorization. And they would be long-term lawful permanent residents or lawful permanent residents, people who have green cards, who are legally admitted to the United States, would have been convicted of criminal convictions. Most criminal convictions will subject a non-citizen to deportation. So those are the groups that are in detention. The government can detain any one of them. The priorities, however, that have been set forth by the Obama administration are not as broad, if you will. The Obama administration wants to hold people who are, security risks, have criminal convictions in their background. They don't necessarily want to be holding people who are simple visa overstays who have no criminal background. In the detention system has always existed. We've always detained non-citizens that we sought to deport. What happened, though, is in 1996, under the laws that were put in place at that time, there was a whole scheme called mandatory detention, where the government was required to detain virtually any non-citizen of the United States with a criminal conviction. So that greatly expanded the amount of people that were subject to detention and could not be released under any circumstance by an immigration court or otherwise. And that led to the building of all these detention facilities that we have now, including the one in Batavia. So now, I think that's what caused the crisis, if you will, that people see today when they talk about immigration detention and all the issues that it brings. We're detaining a huge number of people, and not all of them necessarily would be considered flight risks or dangers to the community. We just detain them by definition because they have the kind of crime that makes them deportable. For example, you could have a long-term permanent resident who has 2 petty larceny convictions. He's subject to mandatory detention. Arguably, if he's a permanent resident, he has strong ties to the United States, so he's not a flight risk, and he even has a defense against deportation, which motivates him to go to court and not flee. And secondly, you can't argue that someone with petty larceny convictions is a danger to the community, or it doesn't obviously fit the general idea of what a dangerous person is. So that's where the problem arises, is that we're detaining too many people, which at a cost of, I believe it's over $100 a person per day now. And that's what I think advocates are very concerned about.
So in terms of the living conditions, obviously I'm going to back up for a sec. The two reasons for being detained are fear of flight and or conviction of a crime for
basically,
right?
Yeah.
Okay. So in terms of the living conditions, I'm curious what your opinion of how the conditions in those detention facilities are.
Well, the detention facilities in the United States, there's a number of different types. You have a place like the Federal Detention Facility in Batavia, which is owned and operated by the Department of Homeland Security. It's a federal government operated facility. Women in this jurisdiction, at least, are not held at Batavia. It holds only men. So when a woman is subject to detention, she's going to be held in a county facility, which Immigration Customs Enforcement, ICE, contracts space from. They might be held in Niagara County, they might be held in Wayne County, in Chautauqua County, in Allegheny County Jail. And then, not locally, but in many parts of the country, especially out west, a lot of the detention facilities are privately owned by CCC or CCA, GEO, all of those private corporations that are in the prison business. So the conditions can vary depending on where people are held. There was a time immigrants were held in the Erie County Holding Center, and as you know, that exploded. The conditions in the Erie County Holding Center were criticized by even the U.S. Department of Justice. Now, even before that story broke, the immigration authorities had stopped their contract with the holding center. So we haven't seen immigrants detained in the Erie County Holding Center. But you might have people who have no criminal background whatsoever who are being held in county facilities, and usually they're segregated. I mean, usually they segregate people based on if they're immigrant detainees or violent crimes and things of that sort. Even the federal detention facility in Batavia has a system of identifying. You have people who have no criminal convictions, only immigration violations. You have the middle people who might have minor crimes, and then you have people with serious crimes. So that can vary. There have been cases where immigrants feel that they're threatened by much more violent inmates. There was criticism years ago of deaths in detention, not getting adequate medical care while immigrants were being detained. The facility that I'm most familiar with, of course, is Batavia. I've been going there since 1999 on a weekly basis at least. I can say that facility is run very well. There's been none of the scandals that I've heard about at other facilities. I don't know if that's because it's federally owned and operated, but they consistently meet all the requirements that they are required to meet by those who have to certify the way they operate. And I know they're very cooperative with our efforts to go into the facility in order to explain to the detainees what their rights are. They've never stood in our way, and they've even made the process much easier than even some of my counterparts at the other organizations I told you that have a similar funding. They work at facilities where there are lots of obstacles in their way. They're forced to wait for a long time while the detainees are gathered. They're not given some information that might make it helpful to them, that we have access to, for example. And so that just varies from location to location.
Do you think that's kind of a problem more generally with like the uniformity of the system, because there aren't specific rights outlined?
Well, there are rights outlined. There's been lots of work on trying to create some sort of standard of detention. Back in the 90s, they started that. And if you want to find out more about detention standards, you can look at the web page for Detention Watch Network. But there are detention standards in place that these organizations and these detention facilities, better said, are supposed to be following. And from what I understand, all of them have to be certified by the federal government and other institutions who are charged with that. Now, whether they violate, that's something else. But the standards do exist.
And so, is there also is there like oversight, making sure that these standards are like enforced? Or
There are supposed to be oversights. Yes, the standards include things like allowing counsel access to their clients at all times, dealing with the ability to contact people by phone, medical. Access to medical services, religious services. At Batavia, you might be surprised to know that they have Rastafarian services, for example. They allow Rastafarian services. So the detention standards cover all of those issues. Now, whether other organizations or other detention facilities in the country are violating them, whether they're in compliance, I can't tell you. I know that this place is.
Another thing that I'm interested to talk about as well is bond. So for immigrants, is that the technical term that I would
Bond, yeah.
For those who are like detained, or
Yes.
like is that
Well, not everybody gets eligible for bond.
right?
Because of the 1996 law, there are certain people that are subject to mandatory custody, and they can't get bond. They can't get out. Period.
What are the reasons for that? Or what are the
criminal convictions usually. They have criminal convictions. Almost every criminal conviction, even ones that, like, again, that are not necessarily seen as serious, like petty larcenies, could subject one to mandatory detention. Now, that doesn't mean they don't have a defense against deportation. It simply means that they'll be detained during the process. Other folks who are detained and not subject to mandatory custody can have bonds placed on them at the time of their arrest by Immigration and Customs Enforcement or by the Border Patrol or by Customs and Border Protection, whoever the arresting agent is, can preliminarily set a bond.
Mm-hmm.
And then every person has the right to go once before an immigration judge to have the custody status redetermined. That means to attempt to have their bond lowered or to be given a bond if for some reason they were not given a bond and they're still statutorily eligible for a bond.
Mm-hmm.
There are people we call arriving aliens. Those are people who present themselves at a border point of entry, like say they land at JFK or they come over the Peace Bridge and they have no documentation to come into the United States, no proper documentation. They can be held in detention, for example, if they say, I'm afraid to go back to my country.
Mm-hmm.
Those key words, I'm afraid to go back, I believe I'll be persecuted, require the immigration authorities to allow them to enter the United States so that they can go through a process of establishing that they might be asylum eligible. However, because they're deemed arriving aliens, they're not allowed to have bond. The only way they can be released from detention is through the authority of Immigration and Customs Enforcement.
Mm-hmm. Okay. For those who are eligible for bond, what's your experience with in terms of like the amount? Do you think that's, I'm going to use a loaded word here, but is it a reasonable amount to
What you
afford?
consider reasonable depends. For a poor
Is
person,
it affordable?
I can tell you that in this part of the country, most of the people who are arrested, and in this part of the country I mean, the area of Buffalo, Rochester, Syracuse, towards Albany.
Mm-hmm.
The bonds normally set are between $5,000 and $10,000.
Mm-hmm.
The lowest a bond can be set is by law at $1,500. Let's say most of your Mexican, Central American immigrants who have crossed into the United States illegally and are apprehended in this area, say working or traveling or whatever, and are held at Batavia, are generally held in bonds of about $5,000.
Mm-hmm.
And I do see them pay them. Someone
Mm-hmm.
pays them and they get out. They have more difficulty if they get up towards over
Mm-hmm.
5,000. I have seen some get bonds as low as 1,500. Certainly, if a lawyer comes in and tries to argue to have it lowered, and there's justifiable reasons. Other parts of the country it varies tremendously. If someone is apprehended on the northern border of New York State, for example, up there Champlain, up there they tend to set the bonds at $20,000. Very few people can afford those.
And just so I'm clear, who is setting
That
the bonds?
it could be the Border Patrol, it could be Customs and Border Protection, or it could be ICE.
Okay. And so what are the reasons for different levels?
They have a different view of the world. They have a different view of seeing if this person is a flight risk or a danger to the community.
Mm-hmm.
I've seen people come in from other parts of the country. For example, they might be apprehended in the Chicago area, and because there's bed space locally, they'll transport them here to hold them, and we'll see a whole different thing about how they evaluate bonds. We'll see the bonds coming in at 4, 6, 8,000. These numbers that we're not used to playing with, where you're always with the fives, 5,
Right.
10. They
Right.
tend to be pretty. So it just varies from jurisdiction to jurisdiction how much the bond is set at. The good thing, though, is that everyone does have the right to at least go once before an immigration court to try to have that redetermined.
Mm-hmm.
And that's where we'll often see the $20,000 bonds that are set at the border lowered.
Mm-hmm.
And sometimes even the local immigration authorities will lower them even before they get to a judge because they realize that they're unusually high at 20 grand,
Right.
especially if there's no criminal convictions and nothing. It's just an asylum seeker who crossed over from Canada or something of the sort.
Do you think that there's I want to make sure that this is a focused question, but do you think that the way that bonds are set now are fair, I would say?
I mean, it's hard to say. The government says that they follow some sort of, for lack of a better word, a checklist
Mm-hmm.
to determine. I don't know how you can use a checklist and then come up with a $5,000 bond for a guy in one place and $20,000 for a guy who looks awfully like him,
Mm-hmm.
factually.
Mm-hmm.
So I don't know how much, I think I've always thought it depends on the officers and how they view the world,
Right.
how they define flight risk.
Right.
Some will say you're a flight risk if you're using false documents.
Mm-hmm.
Some of these folks have gotten false documents in order to work.
Mm-hmm.
And some officers will see that as a high flight risk. I mean, if you manage to create false documents and create this identity, then you're a high flight risk.
Mm-hmm.
I suppose others will see that as, this guy needed to work and
Right.
support his family.
Right.
That's not necessarily an indication of flight risk.
Mm-hmm.
I mean, they're very personalized in a sense.
Right.
I mean, there's just some standards they say they look at. Do you have an address in the United States? Do you have family that's citizens or permanent residents in the United States? How long have you been in the United States? How have you entered the United States? Did you enter legally, illegally? Do you have any criminal arrests in in your background? Those are the factors that they're supposed to look at. But what weight they give them each is probably a very personalized decision.
Kind of related to that, I'm going to give you two unrelated questions, and you can pick and choose. The one thing that I wanted to get back to really quickly is for determining whether from moving from an affirmative proceeding to a defensive proceeding. So is it the same people who determine who can deny your case? You said it before. Who denies your case? If you're in an affirmative proceeding.
Okay, there's no such thing as an affirmative proceeding.
Okay.
Okay, we got to take that out.
Okay.
There's such thing as filing asylum.
Right.
Affirmatively.
Okay.
Okay.
Sure.
That's the only. Well, not the only, but that's one of the applications that can be made with this word affirmatively. That means that you can walk off the street and go into an Office of Citizenship and Immigration Services. That's the benefits branch. You know that the Department of Homeland Security is divided into three branches. You have the Citizenship and Immigration Services. They do only benefit adjudications. They don't have any enforcement power at all. It's adjudications, naturalizations, and permanent residencies and others. You have Immigration and Customs Enforcement, which is divided into the ERO, the Enforcement and Removal Operations, and the Investigative Branch. Okay, they're kind of a police unit, right? And then you have the Customs and Border Protection. Those are the guys at the airports and at the borders that are checking your documents every time you come into the United States to see what you're doing here and that your documents are in order. One branch of CBP is, of course, the Border Patrol. All right. So, an affirmative application is an application you make when you are not in deportation proceedings.
Right.
Before a CIS officer. You go to an interview. It's not judicial. There's no government counsel cross-examining you and anything. It's an officer at a desk who's interviewing you on the merits of your application. Certain applications can be made that way. Not all. Then there are people who are out of status, who are apprehended by immigration authorities and placed in removal proceedings. In removal proceedings, there are a number of applications that can be made as defenses. Some of them are broader than the ones you can make affirmatively. Okay? Asylum is among them too. So what would happen is, if you're talking about asylum, you would file your application with CIS, Asylum Office. You'd go to an interview one day. After your interview, the asylum officer would determine, no, I don't believe that you have met your burden of proof. I'm going to refer this to an immigration court. That means that you're written up, you're placed into deportation proceedings, you may or may not be detained, and you can go in front of a court and you can raise that application de novo before an immigration court as a defense against deportation. There are no affirmative proceedings.
Right.
That would be the same as, say, I'm a U.S. citizen, I marry a foreign-born man. I want to get him a green card, a permanent residency. We do all the paperwork. One day we go in for his interview on permanent residency. And something happens in the interview and the officer says he's not eligible to become a permanent resident. He was arrested 10 years ago for marijuana. So we can't make him a permanent resident. Okay? What would happen is, at that point, they would deny the application for permanent residency and they would put him into removal proceedings. Now, once he's in removal proceedings, he can renew that application for permanent residency, if he so chooses, or apply for some other form of relief that might be only available in removal proceedings.
I guess what I was trying to get back to was basically in terms of like uniformity of decision making, because it sounds like from setting bond, are the cases? Do you feel like the cases are uniform? Like the decisions that are made.
Well, the decisions that are made on applications have to be made in accordance with the law.
Right.
Okay, so we know as lawyers why wouldn't you get permanent residency? I could rattle off all the reasons why a foreign-born person, even if they're married to a U.S. citizen, isn't going to get permanent residency. There's a number of things that disqualify you. So that's very uniform. Yeah, that's uniform. There is some degree of discretion that they have on these applications, but by and large, they usually can point to something that's in the statute that says you're not qualified.
Right.
We're going to deny this. So that's very uniform. It's when there's a discretionary element that there's perhaps how people exercise that discretion. Although we don't see that so much with the examiners at the CIS level. The discretion is more, the judges can vary more in their exercises of discretion. It comes into play more, I think, in asylum, because in asylum there's just so many factors at play. There's the country conditions in that country, how you see them.
Right.
Are people like that really being persecuted? I mean, even as lawyers, when people walk into our office on a daily basis and say, I want your help to apply for asylum, we'll talk to them. So what's going on? What's going on? They'll tell us a story. And they're absolutely convinced that they're going to be persecuted or tortured when they return. What do? First thing we do when they leave is we go on the internet and we look up their country. And sometimes we say, we don't see it. There's not a single report that says someone like him is going to be persecuted. It's just, I don't see it.
Right.
Yeah, there's been skirmishes with the police and there's this, there's that, but we don't, and so we tell the person, we're not going to take your case. So that kind of analysis happens in every asylum case, from the point as whether an attorney would take it, especially an attorney who's not motivated by money. We don't ask for money from our clients,
Right.
so there's no
Right.
financial. We can just say we just don't like the case. We don't
Right.
think you're going to succeed, and we'd rather have someone who we think has a stronger case. So there is that at the judge-making level. I mean, obviously judges are human, and they have their own perception, and it depends how well the case is prepared. It depends if there's expert witnesses, if there's forensic evidence. With our clients who have suffered past persecution or torture, the first thing we'll do is try to get a doctor to evaluate the wounds, the scars on their body, to tell us, yeah, that looks like it was a electric shock. Yeah, that looks like his hands were tied by ropes. Those are, these kind of scars. Those kinds of things, if they go into evidence, are going to help a judge understand more than someone who has no evidence of the sort, and there's no country conditions evidence that supports this claim, saying that this is, this is what's happening in the country. If you look at statistics, and you can find them easily, Syracuse University has a system called Track. The asylum decisions throughout the country vary. So there is the greatest amount of variance in asylum decisions from judge to judge throughout the country. In that sense, there is some question about how uniform the decision making is.
Right.
But it's a very difficult area of law because, as I said, even we sometimes make those conclusions. We had a case once that we thought was never going to win. I mean, we researched and researched, and we said, where's he getting it from? The asylum officer granted the guy asylum. I even talked to an expert on this country who said, I don't see it. I don't think he's going to get persecuted. But he got it. So there's always some personal element with asylum, because you're assessing what's going to happen in a foreign country to this particular person based on these particular characteristics and how he manifests them, or, So asylum is very difficult.
Another thing in terms of like the structuring of those judges, I know they're part of the Department of Justice. I've read from some advocate papers, basically. They say the very fact that the judge is part of the Department of Justice and is appointed is part of it's basically the prosecutor and the decision maker, and they think that is systematically unfair. Do you have an opinion on that?
Well, it was worse. It was worse before. They were all part of the same department. In the 80s, they split them up, and they made what was then INS. They had the INS branch, because the judges used to be part of the Immigration Naturalization Service. So that was exactly the critique then, and that led to reform. Judges became part of the Department of Justice Executive Office of Immigration Review, and others, and the defense, or the prosecuting. We're really not talking about prosecuting, it was crime, but the government's attorneys were part of INS and then the Department of Homeland Security, separating the two organizations. They're not part of the same branch of the government. So there is now a differentiation. They don't come from the same branch. I think some advocates complain that many of the people who become immigration judges were once attorneys for the government. And there are a lot that do. They're not exclusive, though. In some courts, there's people who did the work I did, who have become immigration judges. I don't know that is necessarily where I'd hang my hat in terms of critiquing the system, because it was once true that they were all from the same agency. Now they're two different agencies. The Department of Justice, the EOIR, and the Department of Homeland Security prosecutes or represents the interests of the government.
In terms of your critique of the system, where would you think where do you see the major flaws laying right now?
I don't think we
now?
need to detain people
Mhm.
as much as we do. My critique is not so much with the systems, with the laws. You know, it's in some ways all of these people, all of us in the system, judges, government lawyers, immigration customs enforcement officials, me, we gotta play by the laws.
Mhm.
And if we don't like the laws, you know, we're stuck with them.
Mhm.
I mean, Congress passed this law saying all these people had to be mandatorily detained,
Right.
even if they had petty larceny convictions.
Right.
So these officers go out and they have to arrest people and they have to detain them. So the laws need to be changed.
Mhm.
The 96 law took away discretion from immigration judges, requiring them to basically order removed any permanent resident, no matter how long he's been here, and in some cases, even if he's performed military service for the United States, if he has a crime called an aggravated felony. And an aggravated felony under immigration law can be a crime that's not even a felony and not even aggravated.
Mhm.
It can be a crime of theft where the judge imposed 1 year sentence even though your guy serves 90 days in an alternative program.
Mhm.
Okay, that's the problem. It's the law that's the problem, in my estimation.
Mhm.
Because there are many judges I know who would grant relief to these people if they could, but they can't. Their hands are bound by these laws. The 1 year rule that makes asylum applicants have to apply for asylum within 1 year of admission. That's the law. That's a problem with the law. The judges, you know, they have to follow the law. So you have a lot of, I think the flaws are in the law.
Mhm.
And that's what I'd like to see more reform of is these laws that lead to these system problems in the system as we perceive them.
Right. Is the 1996 law? Did you say that's been changed since then?
No,
Or
it's still in place.
Okay.
It's Bill Clinton's legacy.
Oh, okay.
Yeah, it's Bill Clinton legacy. The 1996 Illegal Immigration and Reform Act, or whatever.
Uh-huh.
It has a long name.
Yeah.
It was a horrendous law. It changed many facets of immigration law, and they're still in effect today.
And do you think another question that I'm curious about? You said that obviously judges are basically underfunded right now. Too many cases, too few judges. Do you think a similar problem exists with detention facilities? Do you think funding for detention?
No, there's tons of funding for detention facilities.
Mm-hmm.
Like I said, the budget, when you compare the budget of the Department of Justice, EOIR, the people who, and the Department of Homeland's ICE budget, it's a large difference.
Has that changed since after September 11th at all?
I can't
terms of
tell you
budget?
exactly financially. I mean, probably, my guess is probably. I mean, if September 11th changed the whole system, as
Right,
you know. They
right.
did away with the Immigration and Naturalization
Right, right.
Service and created another department, the Department of Homeland Security. So that put everything on its head, and in terms of funding. But the
Right.
funding has consistently gone up over the years.
Right. Okay. In terms of, I think we've covered the most of it. I guess I'm just curious if you have basically any other critiques or any other complaints you'd like to air about your experience so far, or anything else that you feel relates to like kind of human rights abuses and what you see in terms of the laws like you were talking about, or
I think I've covered everything. I mean, I can get angry about the results in an individual case.
Right.
I cannot like those results and get
Right.
really angry about them and think the whole system is messed up
Right.
because of that one case.
Right.
But if I sit back and try to look at it more objectively as a system, I've told you what I think about it, or what it is, what the reality about it from my perspective is. That doesn't mean that, I don't get angry if certain things happen to certain clients. I feel pretty fortunate that I work in a part of the country where things are very reasonable, and I believe that we can generally reach results that are satisfactory to both sides of this equation, whether it's the government and us and our clients, by and large. We also, sometimes we just have to go up to the circuit courts and get our results there.
Right.
But at least they're still open to us, because that's another thing that happened after 9/11, is cutting the jurisdiction of the circuit courts to review immigration cases under Real ID. And that was a shame too, because that eliminated from circuit court review any case that involved an appellate issue on discretion.
Mm-hmm.
And a lot of these cases, as I said
Right.
earlier, have a discretionary element. So now we can't take those up to the circuits.
Mm-hmm.
And so was another disturbing legal change. Again, these are the laws. This is Congress. I
Right.
blame Congress more than I blame the players in some
Right.
ways.
Okay. Okay. Great. Well, I think that concludes it. Thanks for your
Great.
time.
Okay.